Welcome to This Explainer. Today, we're taking what usually feels like a massive, intimidating legal headache and translating it into an empowering, step-by-step roadmap for Georgia residents. If you're looking to resolve a dispute efficiently, save your valuable time, and completely dodge those massive attorney fees, well, you are absolutely in the right place.
So picture this. You hire a contractor to do a home renovation. You pay them, but they completely botch a $5,000 repair job. And then they flat out refuse to fix it. It's infuriating, right? You might feel totally stuck, maybe assuming the legal system is just a playground for the rich, and that hiring an attorney is going to cost you way more than the $5,000 you lost in the first place.
But here is the really good news. In this explainer, we're going to show you exactly how understanding Georgia's magistrate court process puts the power completely back in your hands. You literally do not need an expensive law degree to fix this. This system was built specifically for you, the everyday citizen, to get justice without jumping through impossible hoops.
All right, let's dive into the roadmap. We're breaking the whole journey down into 6 simple steps. 1. Welcome to magistrate court. 2. Preparing before you file. 3. Filing and serving papers. 4. Your day in court. 5. Collecting your court judgment. And 6. Pitfalls and final resources.
Step 1. Welcome to magistrate court. Taking on everyday disputes. So in Georgia, you won't actually find a building labeled small claims court. Instead, magistrate court handles all of it. And what's incredibly cool here is that Georgia offers one of the highest small claims limits in the entire nation. You can sue for up to $15,000 in principal damages. We're talking broken contracts, property damage, unreturned security deposits, you name it. Plus your court costs and post-judgment interest, those can actually be added right on top of that $15,000 limit.
Now, this is a total game changer when you compare it to state or superior courts. Over there, you practically need a lawyer just to survive the complex rules and jury trials. But magistrate court? No juries at all. The judge just decides. It's explicitly designed so you can represent yourself, or appear pro se, as they say in the legal world, all while enjoying way lower fees and a much faster resolution. Step 2. Preparing before you file. Setting up your case for success. Okay, before we just go sprinting down to the courthouse, we have to make sure our claim is actually valid. And the absolute most crucial first step here is venue. Listen, you can't just file your lawsuit wherever it's convenient for you. Georgia law is incredibly strict about this. You have to file in the specific county where the defendant actually resides or physically operates their business. If you file in the wrong county, your case gets tossed out and you completely lose your filing fee.
Next up, it's time to build your case. First, check your timing. In Georgia, you generally have 6 years to sue on a written contract and 4 years for an oral contract or property damage. After that, you'll want to send a formal demand letter via certified mail. Now, it's not strictly legally required, but it acts as a final good faith attempt to settle things out of court, and honestly, judges really love to see that. Finally, gather pristine physical evidence. I'm talking texts, signed contracts, clear photos. Get all your receipts together. Step 3. Filing and serving papers, making it official.
All right, with your rock-solid evidence in hand, it's time to fill out what's called a sworn statement of claim. The cool thing is you can do this entirely online using a portal like eFileGA, or you can just go in person to the clerk's office. It's also super affordable. The exact costs vary a bit depending on your specific county in Georgia, but the base filing fee is usually just between $45 and $100. Even when you add in the sheriff's service fee, it generally won't break the bank. And hey, if you truly can't afford it, you do have the option to file a poverty affidavit to request a fee waiver. But here's the catch. Filing is only half the battle. You can't just walk up and hand the legal papers to that bad contractor yourself. No way. Georgia law requires formal service of process. This means you have to pay a sheriff's deputy or a court-approved private process server to officially deliver those documents. Once they're officially served, the clock starts ticking, and the defendant generally has exactly 30 days to file a written answer with the court.
Step 4. Your day in court, facing the judge. Usually, your trial is going to be scheduled about 30 to 60 days after those papers are served. But wait, what if that contractor just completely ignores the lawsuit? Well, if they miss their 30-day deadline to answer, you can step in and request a default judgment. This is basically a golden ticket. It's an automatic win. You literally win the case without even having to go through a full trial, all because the other guy just failed to defend himself.
However, if they do file an answer, it's time to prepare for a bench trial. First rule of thumb, organize your evidence into 3 physical copies. One for you, one for the judge, and one for the defendant. Second, and this is huge, written witness statements are completely useless in Georgia magistrate court. If you have a witness, you have to bring the actual person into court to testify live, period. Finally, just practice basic courtroom etiquette. Have a brief, factual opening statement ready, speak clearly and directly to the judge, and whatever you do, keep your emotions in check. Just stick to the facts.
Step 5. Collecting your court judgment. Getting your money. The judge bangs the gavel, and boom, you win. But I gotta give you the hard truth here. Winning a piece of paper from the judge does not magically deposit $5,000 into your bank account. The court is not going to collect the money for you. Also, quick side note, if things didn't go your way and you lost, you generally have 30 days to file an appeal. But back to winning. To actually force the defendant to pay up, you have to request a writ of feri facias, or FIFA for short. This document is essentially a lien that allows you to legally seize their assets or go straight after their income. One of the most effective ways to use that writ of FA, is by setting up a continuing wage garnishment against the defendant's employer. Under federal and state law, you can legally deduct up to 25% of their disposable earnings from every single paycheck until that entire debt is paid off. And even better, in Georgia, your unpaid judgment automatically accrues a 7% annual interest rate while you wait. Step 6. Pitfalls and final resources. Navigating the traps. Before we wrap this up, we absolutely have to talk about the hidden traps that can completely ruin an otherwise perfect case. Number 1, suing a business using a nickname or a doing business as name instead of their exact legal entity name. This is literally the most common reason cases get thrown out in Georgia. Always verify their exact legal name on the Georgia Secretary of State's website first. Also, remember our venue rule. You have to file where they live or operate. Make sure you actually print your physical evidence, and please, never try to split a $20,000 claim into 2 separate $10,000 claims just to squeeze under that magistrate court limit. The law strictly forbids that. Now, remember that the court clerks are incredibly kind and they're super helpful with the actual filing process. But by law, they cannot give you legal advice. They can't tell you who to sue, and they can't tell you what to say. So make sure you take advantage of free state resources. The Georgia Magistrate Council website is absolutely packed with self-help guides and free statewide forms that you can download right now. We really hope you feel empowered by all of this, but please keep in mind this explainer provides general guidance based on source material and is strictly for educational purposes. We're laying out the roadmap for you, but you should always consult a qualified legal professional for personal advice regarding your own unique situation. So, are you ready to stop feeling stuck and actually take that first step toward getting what you're owed? The small claims system in Georgia was built exactly for people like you to find justice, without losing your shirt to massive attorney fees. What are you waiting for? Get out there, gather your evidence, pinpoint your proper venue, and take back control of your dispute.